Recording in progress.
Доброго дня, шановні колеги.
Good afternoon, esteemed colleagues. We'll just wait a bit more until everybody shows up.
Радий вітати учасників нашої конференції.
I'm really happy to welcome all of you again. I'm Vladimir Sokolov, and I'm really honored to moderate the second session of our conference. And the topic of this session too is protection of main electoral rights of the citizens. During this discussion, thanks to our speakers, will become familiar with main peculiarities of protection of voters' rights. Also will familiarize with the structure of electoral systems, so Moldova, Germany, and some other countries, and peculiarities of protection of the electoral rights in these countries. Let me introduce to you our first speaker, but before that I'd like to kindly ask all of you to take part in discussion. You can ask your questions in the chat, and after completion of the session, we'll try to receive answers from our esteemed speakers. So I'm inviting to the floor Halina Kalashnikova, the Justice Secretary of Judicial Chamber at Cassation Administrative Court. She will talk about ensuring case law of Ukrainian courts. Well, okay, as you know, the case law is a system of legal provisions which actually interpret the legislation, may add something or solve the conflicts between different legislative provisions. Hence, the case law is formed through application of the courts of the legislation. In specific cases, the law on the judicial system requires ensuring consistency and unity of the case law based on the principles of the rule of law, equality of the citizens before courts and law, impartiality of the court, legal certainty, and lawful expectations. All these principles require that the courts apply consistently the legislative provisions, thus ensuring predictability of the judgments, which means the sustainability of the case law. In turn, this allows for using overcoming various gaps in the legislation, removing mistakes in the application of the law, and to ensure the similar understanding and interpretation of the legislation. As European Judges Consultative Council stated, the consistent application of the law ensures equality before the law and legal certainty. The consistent application of the law ensures confidence of the public and improves the perception of the public of the fairness of justice. Based on our experience, we can identify the main ways to resolve some typical disputes. The judgments are the results of the application of the law exercised by the court. At the same time, under the existing system, this is the function of the supreme judicial authorities, which make final conclusion concerning the application of the law, which creates a precedent legislation, where the key role belongs to the case law of Supreme Court, which becomes kind of a source of law. In view of the legislation, in particular Article 5 and 6 of the law on judicial system and status of justice, according to these articles, the opinions expressed in the determinations of the Supreme Court are binding for all public authorities with reference to specific legislative text that need to be taken into consideration by other courts for purposes of their case law. Thus, this becomes very important for purposes of regulation of legal relations which are not described in the law with sufficient clarity. Part 1 of Article 36 of Law of Ukraine on Judicial System vests the Supreme Court with the task to ensure the consistency of the case law. So the Supreme Court is responsible not only for correcting already committed mistakes in the application of the law by delivering judgment at the level of cassation instance, but also to ensure the prevention of any further mistakes of this kind. The elaboration of the consistent case law requires removal of discrepancies. The importance of this consistent case law is confirmed with a number of cases that were actually decided in the years 2020-21 in the election disputes. And the aforementioned elections were or have been conducted and are conducted and will be conducted during the current mandate of the Parliament based on the law on election of People's Deputies of Ukraine, which had effect in 2019 too. Here you can see the important role of the case law formed by the Supreme Court during the solution of disputes in 2019 for purposes of resolving the disputes in further cases. I need to say that these legal positions are effectively used by the Cassation Court, which is very important for resolution and adjudication of the cases in the years 19 and 20. Some important aspects here. One of contradictory issues was whether any omissions committed by a public authority should be interpreted as unlawful. In its case law, the Administrative Cassation Court developed their own definition formulated during the presidential elections in 2019. According to this, the unlawful omissions of a public authority consist in the acts of official when such official does not make or does not deliver decisions or undertakes actions which are within the competence of this specific public authority. If such actions or decisions were objectively necessary but were not implemented. So here, when there were complaints against the Central Electoral Commission, the court found that the very fact of improper exercise of the important actions by a public authority, also specific circumstances need to be taken into consideration if such circumstances contributed to non-performance or to failure to act, including consideration of duration of such omissions and the grounds for it. This same approach was used in the recent judgments of the Administrative Cassation Court. Importance have also other legal positions that deal with the registration of the candidates, in particular talking about paying the pecuniary security is a condition of registration of a candidate at the electoral constituency, and failure to pay such security is a violation of the legislation. And hence, if this security is not paid in person by the candidate, then such candidate would not be registered, because this is the concept to ensure the purity of the elections. Indeed, if the security is paid by anybody else but not the candidate, this candidate becomes financially dependent on the actual payer, which violates the principle of political independence of potential people's deputy. And the court demonstrated the consistency of its case law during the election of 2021. The court applies consistent case law in the matters of registration of the candidates under the same with the same last names. Certainly, all these candidates have the same rights to run the elections, but often the purpose there is to prevent, to put obstacles to another, maybe more famous candidate to take away some votes from such a candidate. But there should be objective criteria to prove the abuse of such rights. And this is a matter which still needs to be resolved by the legislators. Consistent case law and interpretation of The legislation is depicted also in some determinations of the Supreme Court, which have impact over the application of the law by public authorities, in particular Central Electoral Commission. In particular, 2019, the court criticized to formalize the approach of the Central Electoral Commission to assessment of the documents submitted by the candidates. The court stated that this mechanism creates ungrounded obstacles for a candidate to exercise his or her electoral right. In 2020, the court applied this position in a wider way by stating that the Commission did not recognize the passport of a citizen based on informal information. I should mention that later on, no disputes on this grounds have ever taken place since then. And the case law and the legal positions of the Supreme Court will still remain important for newly applied legislation. These are the main points of my presentation today. Thank you very much for your attention.
Дуже дякую вам, Олена Володимирівна, за таку змістовну чудову доповідь. Дійсно, в умовах суперечливості.
Thank you very much for interesting presentation. In this situation of contradictions and gaps in legislation, case law is very important for resolving this issue. So important is to develop this case law practice and inform society about your judgments regarding legal relations, electoral process. Thank you very much. Thank you. So we move further. It's my great pleasure to introduce to you our next presenter, President of C3 Administrative Court of Lithuania, Mr. Gintaras Kirjavičius. His presentation is titled Challenges in the Field of Electoral Law of Lithuania. So we are listening to you with it.
I would like to ask your team to show my slides. Are you hearing me? Я слышен или нет?
The interpreter can hear you very well.
Працюють. Слайди у нас вже на екрані.
Your slides are on the screen. They can hear you very well.
Yeah. Before starting my presentation on the issue, I would like to present the current election system in Lithuania. Elections to the national parliament are held through a mixed electoral system. The 70 members of the parliament are elected under a party list-based proportional representation system, and another 71 members are elected in a single-member constituencies. President of Republic of Lithuania and mayors in the municipalities are elected through a majoritarian system. The elections to the municipality councils and to the European Parliament are held in accordance with a party list proportional representation system. Next slide, please. Three tiers of electoral commissions led by the Central Electoral Commission organize elections. The composition of the Central Electoral Commission is designed in a manner to ensure its impartiality. The chairman of this Central Commission is appointed by the Parliament. The rest of its members are chosen by Seimas Parliament, from a list of candidates proposed by the President, Minister of Justice, Lithuanian Lawyers Association, and delegated by the political parties, which were successful in the last parliamentary elections. All elections commence in the same manner, the registration of candidates and mapping out of constituencies. Once the elections are announced, exhaustive rules on political advertising and campaigning come into force. As a general rule, electoral disputes during the election period are adjudicated by the Supreme Administrative Court of Lithuania. Due to the nature of electoral disputes, electoral laws prescribe very short periods to issue a decision upon the matter. For example, Supreme Administrative Court of Lithuania has only 48 hours to issue a decision under the electoral laws to the parliament. Next slide, please. When turning to discuss particularities of electoral disputes in Lithuania, it should be noted that the past 2 years were abundant in such disputes. Because all of the aforementioned elections took place within this period. The majority of disputes were related to the recognition of a status of a candidate, to the issues of political advertising, campaigning, and funding of the political campaigns. Speaking about the cases related to the recognition of a status of a candidate, the applicants had most often contested the decisions of a Central Electoral Commission, which established that the person had failed to comply with the requirements of the candidates under the relevant electoral laws, and therefore they were refused registration, or the status of an already registered candidate was revoked. Typically, such decisions were made by the Commission on the grounds that the individuals nominated to be the candidates failed to submit all the electoral application documents, failed to disclose all the required, according to law, information, or failed to collect the required number of voters' signatures. Please, next slide. The most prominent recent issue in the Lithuanian electoral law concerns the right of former public officials who were impeached for breaking the oath to stand as candidates in the elections. This particular issue has already escalated beyond the Lithuanian legal order, as the Supreme Administrative Court of Lithuania has submitted a request for an advisory opinion to the European Court of Human Rights under the protocol number 17 to the Convention of Human Rights and Freedoms in September last year. The issue dates back almost 20 years to the impeachment of a former president of Lithuania. The impeachment procedure encompasses the inquiry to the Constitutional Court of Lithuania for an opinion on whether the politician in question break his presidential oath and those violated the Constitution. The Constitutional Court had decided that both were true in the particular case. Furthermore, in a later ruling, the Constitutional Court provided certain insights into the constitutionality of electoral laws and noted that an impeached person who had committed the aforementioned violations may not hold an office which requires to take an oath under the Constitution. This jurisprudence, in effect, restricts the impeached individuals from becoming members of a national parliament. In 2011, the Grand Chamber of the European Court of Human Rights issued a judgment and found the above-mentioned restriction to violate the Convention. Taking away the right to be elected to the indeterminately was deemed disproportional. Among other reasons, the Strasbourg Court has emphasized the permanent and irreversible nature of the applicant's disqualification from holding a parliamentary office, which led to the conclusion that Article 3 of Protocol number 1 to the Convention was violated. The next legal material development was made in the later rulings, the Constitutional Court of Lithuania, dealing with the implementation of Strasbourg decision. The Constitutional Court considered an amendment of constitutional provisions to be proper way in to implement this Strasbourg Court decision. The Constitutional Court also emphasized that the Constitution requires to respect the international law and to adapt the amendments without an unreasonable delay. Even though numerous constitutional amendments were drafted and reached the initial stages of a legislative procedure, the Lithuanian Constitution has not yet been amended to implement this judgment. Please, next slide. No doubt that the constitutional jurisprudence creates consequences not only for the impeached former president, but also for other politicians who broke the oaths and violated the constitution. Several politicians were impeached from the national parliament, and for one of them, the Central Electoral Commission denied an opportunity to participate as a candidate in the last parliamentary elections last year. The decision of the Central Electoral Commission was based on the fact that the person in question was impeached from the national parliament, and the Constitutional Court found that she broke her oath and violated the Constitution. The decision of the Central Electoral Commission was appealed to the Supreme Administrative Court of Lithuania, which in September last year issued a decision to make an inquiry to the European Court of Human Rights and an advisory opinion procedure. The court noted that Lithuanian government is taking a long time to adopt the necessary amendments to implement the national legal order, the above mentioned Strasbourg Court decision. Among other things, a doubt was raised whether the applicant's rights are not violated due to the continuous legal certainty causes by the lack of legislative instruments. Supreme Administrative Court of Lithuania has forwarded questions. You see these questions in the slide. And this is an important case, and its outcome is expected to bring useful insights into how requirements of a convention must be implemented in the national law. The effect may be significant to Lithuanian legal system and electoral laws in general, and to the similar cases. Besides the material effect, the significance also lies within the instrument itself. The right to make an inquiry for an advisory opinion as an instrument of dialogue between national and international courts in effectively protecting human rights at the national level. It also allows to avoid a lengthy procedure when national remedies have to be exhausted prior to bring the case before the European Court of Human Rights. Next slide, please. As far as the second category of disputes, those related to the political advertising and funding is concerned, it is worth noting that from an international perspective, Lithuanian electoral laws may be distinguished by a strong focus on political campaigning, which is governed by extensive and relatively strict rules. The central pillar on this issue is the prohibition to political campaigns to be founded by legal persons and the limits set out for the donations of national persons. Most of the rules are laid out in the law, special law on founding and the law on political parties. Please, next slide. Currently, the largest allowed annual donation by a national person is 15,000 euros. Besides this limit, it is forbidden for national persons to make a donation exceeding 10% of their declared annual income. Next slide, please. Under the law on funding, a political campaign is defined as any activity related to corresponding elections or referendum, while political advertising is defined more narrowly as spreading of information by a state politician, political party, or its member, political campaign participant in the name and or interests of any kind, which is intended to influence motivation of voters for voting in elections or referendum, or promotes a state politician, political party, its member, or a political campaign participant, and as well as the ideas, goals, or political program. This includes information which is disseminated above for reimbursement or for free. One of the more notable recent disputes in this category concerned a television series linked to a member of the Lithuanian Farmers and Green Union political party, which was the ruling party in the national parliament in 2016-2020. The Supreme Administrative Court of Lithuania issued a decision in this case where it agreed with the Central Electoral Commission's conclusion that some parts of this television series did fit the definition of political advertising. The court noted that the show included the aforementioned political party's logo and promoted its political ideas, goals, and even political program. This category of disputes also covers issues related to the public debates of the candidates. Due to the fact that advertising from private funds is restricted, candidates are provided with an opportunity to appear on debates organized and streamed by the public national broadcaster. In 2020, the Supreme Administrative Court of Lithuania had received a complaint where the grouping on the candidates for the debates in the national television was contested. The applicant maintained that more popular candidates were placed in one group, while less popular in another, those, in effect, diminishing the dissemination of information on the views and political program of the later group. The Supreme Administrative Court of Lithuania found that the Central Electoral Commission's decision to group the candidates based on the results of voters' survey regarding the approval ratings denied the candidates equal opportunity to compete in the elections. The court noted that a more appropriate manner to arrange candidates' turns in the debates was to draw them randomly. Yeah, and last slide, please. To conclude, it may be noted that the majority disputes arise and deal with in period prior to the day of election. The Supreme Administrative Court of Lithuania had received 117 complaints regarding lawfulness of a Central Electoral Commission's actions in the last year with regard to the parliamentary elections, while only several complaints were filed with the Constitutional Court, which hears the cases once the voting polls are closed. Furthermore, even though the scope of the electoral laws is limited and the disputes may be attributed to the several large categories, in fact, they are very diverse in nature, bringing into questions not only the interpretation of the national laws and constitutional provisions, but also extending to the issues of fundamental human rights guaranteed by the international instruments. Thank you very much for attention.
Дуже дякуємо вам, шановний колего.
Thank you very much, dear colleague. I would like to especially underline the importance of the presentation we just heard. that the different features of the election systems, between Lithuania and Ukraine are quite similar, including the problems that you have mentioned during your presentation. We, in fact, have quite similar problems in our work of our courts. That's why it was really valuable to hear the information that you have shared with us. Thank you. Dear colleagues, I have a great honor to give the floor now to a great friend of the Ukrainian administrative justice, President of the Constitutional Court and President of the High Administrative Court of Rhineland land, Germany, Dr. Lars Brucker.
Yeah, Mr. Chair, thank you very much. It's such nice to see so many old friends, good known faces today, like Mrs. Kalashnikova, Mrs. Bilak, Mrs. Hubska. So we didn't meet for a long time. I hope it will be possible soon to meet again in Koblenz or in Kiev or somewhere else. We will see. So first of all, I would like to thank our honorable hosts, my colleagues and dear friends, for the invitation to this conference. And I congratulate you on the Constitutional Day on June the 28th. As we all know, the effective protection of the Constitution, especially the protection of fundamental rights, cannot be achieved without the daily work of administrative courts. Nowadays, the administrative courts are a central component of the rule of law in Ukraine. And in Ukraine, the administrative courts have the responsibility for the judicial safeguarding of the electoral process. As you see, the subject of our conference fits perfectly to the 25th anniversary of your constitution in Ukraine. And now let me describe the situation in Germany. It's rather similar to your constitutional system. The right to vote is part of a subcharter of the basic law, the German Grundgesetz. Then together with party law and parliamentary law, it forms the democratic constitution. This provides the constitutional framework for the political process. The formation of political opinion has to be transformed into political decisions. The act of voting is a central and intermittent interim decision. The election process provides a link between the decision-making of state and society. In the words of the German Federal Constitutional Court, in a democratic constitutional state, elections are the main process by which the people exercise public authority themselves and create legitimacy for the further exercise of authority in their name by the elected bodies. Voting is therefore the fundamental process of constitutional life in which all other state authority is built. But voting can only convey legitimacy if it does not have any serious deficiencies. Sovereign will, the results of the vote, must not be falsified. In view of the fundamental importance of voting, the principle of democracy requires that voting be subject to judicial control. Protecting the right to vote is a compulsory provision of the principle of democracy. The German system for protecting the right to vote follows two main principles. The first, constitutional courts, rather than administrative courts, are primarily responsible for protecting the right to vote. The German Federal Constitutional Court for elections to the German Bundestag and to the EU Parliament, and the relevant state constitutional court for elections to the state parliaments. In general, administrative courts are only responsible for elections to representative councils of municipalities, since municipal authorities known as kommunale Parlamente do not operate as parliaments. And the second principle, the judicial protection is essentially a downstream process, which means that a special complaints procedure known as an election verification process in accordance with Article 41 to the German Constitution is used to check afterwards whether the election was conducted properly. The reasons for this are that the election process should not be hindered by countless individual court cases, and Parliament itself is involved in the first stage of review in the scrutiny of elections. Judicial protection only takes place before and during the election in exceptional cases. For example, constitutional complaints are institutional complaint, judicial review against an election law, and non-recognition complaint from a political party or a party entitled to an election proposal. The principles of the right to vote are set out in Article 38 of the Basic Law, and these principles are almost identical with Article 71 of the Constitution of Ukraine. So to make this part shorter, say something about the judicial protection. In the course of their activities, official election bodies must observe the constitutional electoral principles and ensure compliance with them. The question of whether this has been carried out sufficiently in each individual case is subject of judicial review. Judicial review is of central importance for safeguarding the integrity of elections and therefore the integrity of the democratic process and of the basic rights of citizens in general. The subject of judicial review is as complex and multi-faced as the electoral process itself. This applies first of all in legal terms. All principles of the right to vote can potentially be affected and are to be further substantiated in individual cases by case law of the court. The specific cases can also be varied, ranging from a caretaker who unlocks the polling station too late due to negligence, the voters thereby unlawfully prevented from voting, that's a question then, to targeted manipulation, where constituencies organized by the political majority in such a way that their own candidate was able to benefit. That's a question in those cases. I would like to briefly outline a few examples from the, let me say, colorful bouquet of cases that have occupied the German Federal Constitutional Court and the Constitutional Court of Rhineland-Palatinate in recent years. The first examples are concerning the design of ballot papers. The external design of the ballot papers has often been cause for dispute. In 2006, the Constitutional Court of Rhineland-Palatinate ruled that in the case of a ballot paper folded several times, the candidates listed further down, for example, only visible when the ballot paper is fully unfolded, are not disadvantaged, since a responsible, understanding elector exercises his right to vote in a responsible manner. He can be expected to understand this and to look carefully at the ballot paper. According to the court's decision, this kind of responsible citizen is the guiding principle between the Constitution's understanding of democracy. The responsible voter. For this reason, the Constitutional Court of Saarland, another German land, did not object in 2011 to the fact that a marking arrow on the top of the ballot paper which was supposed to indicate to the voter the column in which the cross was to be made, extended into the field assigned to the governing party ranked number 1 on the list. Of course, this kind of design should still be avoided. It is also clear that the order of the candidates on the ballot paper must not be arbitrary and should abstractedly result from legal regulations. As a rule, according to the voting results of the parties in the preceding election, and parties running for the first time are then added in alphabetical order. The Constitutional Court of Rhineland-Palatinate had to decide in a case that also concerned the design of ballot papers in 2014. The Parliament had passed a law according to which the text "men and women are equal," the wording of Article 3, the German Basic Law in other words, was to be printed on the ballot papers. In addition, the percentage of women and men represented in the body to be elected should be printed. The political objective was to correct the lower representation of women in these bodies upwards through the act of voting. It's some of these terms we heard about before the break from a point of view of European law, but the Constitutional Court unanimously declared this law to be unconstitutional due to a violation of the principle of freedom of choice. Such propaganda, even if its purpose is a legitimate goal, does not belong on the ballot paper. According to the Constitutional Court, voters have the right to be left alone in the voting booth. There's no space for propaganda. Another example for so-called gerrymandering. In 2015, the Constitutional Court had to decide whether the redivision of 2 of a total of 51 constituencies by the legislator violated the principle of equal electoral opportunities. The court was not able to find a violation of the Constitution in this case. There were no indications that the division of the constituency had been carried out under purely personal and/or party political aspects, and that the prohibition of gerrymandering had been violated. In this decision, the Constitutional Court also formulated general criteria for the division of constituencies, in particular an approximately equal size concerning the voters, the number of the voters, the observance of historically rooted administrative boundaries, and the preservation of a certain continuity of the layout. On January the 28th this year, the Constitutional Court confirmed that the legislator had sufficiently reduced the number of supporting signatures for nominations in view of the COVID-19 pandemic and the associated restrictions. Here is some background information on this. According to voting rights, parties that are not yet represented in Parliament must submit a list with signatures of eligible voters who want to support a certain party. This is to ensure that only serious candidates are admitted. Originally, a minimum of 2,080 supporting signatures were needed, and due to the contact restrictions imposed by measures to deal with COVID-19, the legislator reduced this number to 520, so that's only a quarter. Our plaintiff, a political party that had not been admitted because of too few signatures, it had only collected 309, was unsuccessful with its complaint. The number of votes required had been reduced to a sufficient extent according to the Constitutional Court. The Constitutional Court also took into account the fact that 7 other parties had managed to collect the required numbers of signatures. In the meantime, this issue has also reached the German Federal Constitutional Court in view of the Bundestag elections in September this year. However, a corresponding complaint has already been rejected as inadmissible by rulings made in April the 13th and in May the 19th this year, as the applicants had not sufficiently demonstrated a violation of the Constitution. Incidentally, the German Bundestag has now reduced the required number of signatures anyway. Let me come to a last example. The principles of the right to vote also have an impact on the powers of expression of public officials, including and not least members of the government. In one of our last conferences, Mr. Papoashvili told about this term. The German Federal Constitutional Court emphasizes in its case law, most recently in the judgment of June the 9th, 2020, concerning a statement by the Minister of the Interior, that the right of political parties to equal opportunities under Article 21 of the Basic Law is closely related to the principles of generality and equality of choice under Article 38. In their official function, ministers must therefore also observe the requirement of neutrality of state bodies and may not interfere with active competition. However, it is also important that the minister is allowed to participate in the political expression of opinion outside his office as a private person and a party member. On the other hand, he must not misuse his office and official resources, for example, the ministry's homepage, for this purpose. This distinction has also already been specified in a decision by the Constitutional Court of Rhineland-Palatinate in 2014, to which the German Federal Constitutional Court explicitly refers in its ruling. And it's a very nice thing, he referred about 12 or 14 times in its ruling. In these complex issues, case law is therefore so important as well as sensitive because it directly determines the party political battlefield in its rules. On May the 14th this year, the Constitutional Court of Rhineland-Palatinate ruled in a similar context that the President of Parliament may prohibit a parliamentary group. The court left open as to whether he was obliged to do so, from renting its rooms in the Parliament building to the party, for the party to set up its campaign office during the election campaign. The use of the parliamentary group rooms for election campaign proposed by the party was, according to the Constitutional Court, an admissible mixing of parliamentary group and party work, and established an inadmissible political competitive advantage over such parties that were not represented in Parliament. This would represent an impairment of equal electoral opportunities. The President of Parliament was entitled to intervene against this obvious abuse on the basis of his authority. He would, however, have to treat all parliamentary groups equally in this respect. I think that these were indeed some examples from the wide field of electoral law that the courts have to work through. Since we have an almost identical constitutional provision on the principles of the right to vote in Ukraine with Article 71, and in Germany with Article 38, a further and more in-depth dialogue on electoral law issues would certainly be particularly exciting and profitable for both sides. As far as possible, cases are concerned, electoral law is, if I may put it so casually, always good for a surprise, and a particularly demanding field of law from a technical point of view. So let me come to my short concluding remarks. In Ukraine, the judicial safeguarding of the electoral process, which is so central to democracy under the rule of law, is a task entrusted to the administrative courts, unlike in Germany. But this means that administrative courts operate like constitutional courts in this field. This fits in with their comprehensive mandate to provide legal protection against acts of public authority. It would be nice if citizens also recognized the power of the administrative courts to protect their civil participation rights and freedoms. All the best. Thank you very much.
Thank you very much for this very interesting presentation, for your very interesting examples from the case law that you face, that our colleagues in Germany face. Thank you very much for this presentation. Let's keep moving. I'm very happy to give the floor now to the judge of the Republic of Moldova, Marina Grosu, who's going to speak about the case law on election law in the Republic of Moldova. Good afternoon. I'm very happy to greet all the participants. I hope you can hear me well. Yes, absolutely. We can hear you very well. Thank you. We're listening to you attentively. In my presentation, I would like to cover the national case law as regards the election law in the Republic of Moldova. And I would like to look briefly at the legal basis of the election law in Moldova, the structure of the election-related disputes, and some quite high-profile cases related to the election law that took place in my country, including with participation of the international legal institutions. In this case, I'm talking about the judgments of the European Court of Human Rights, and even those cases when the Venice Commission also spoke and also provided its recommendations as to the procedure as such, the procedure of the elections that took place, and about various collisions in the law that we have in my country, which definitely affect the implementation of voters' rights. According to the constitution of my country, the democracy in this country is based on political pluralism. Like in Ukraine, we have quite a lot of political parties participating. This makes us happy because people have the right to choose between different political courses. At the same time, the elections take place periodically. Marina, we seem to have some technical problems. We will try to resolve these problems now. We're trying to find out what the situation is, trying to reconnect with Marina. Unfortunately, the connection has been lost. Perhaps you can proceed to the next speaker while we try to reconnect. Are you giving me the floor? We now have the next speaker, Alla Basalayeva. If you don't mind, let's work according to our agenda. Thank you. I want to welcome Alla Basalayeva, lecturer at the Department of Constitutional Administrative Law, the Department of Law, National Aviation University, and member of the Central Election Commission between 2018 and 2019. She will now present her presentation about protection of subjective passive electoral right. Good afternoon, dear colleagues. Thank you very much for your participation, for a chance to participate in this conference. I'd like to make my presentation about a subject which I think is very interesting: protection of subjective passive electoral right. As part of the election process, we see the active election, both active right, the right to elect, and the passive right, the right to participate in the election process for candidates to political positions. The implementation of these rights are to be protected and guaranteed by the checks and balances mechanism. The protection of the right and the interest of people as regards development of public governance bodies is an element of their implementation. The nature of the elections as a form of the choice to be made by the people has led to some features of the election law. For example, as abbreviated terms for hearings, or a ban to make claims that can violate the process for the preparation of the election, the need to immediately enforce the decisions of the administrative courts. And unfortunately, adoption of the new election code has not solved a number of important issues. And in some cases, on the contrary, it has made it even more difficult for the candidates to see their right to be elected implemented. Let me go into some elements. As the election code has introduced a new system of election, the system of their territorial organization has changed dramatically. For example, as regards the formation of election districts. A district is a territorial unit within which a number of mandates is to be distributed across all of the unit. And in fact, there can be very many versions of the division into districts. For example, from a division in a national district to creating mandates for several, distributing between several districts. But what is important is that the equal passive electoral right is to be guaranteed. This can be found in the decision of the Constitutional Court of Ukraine, number 1-13, which should ensure not only equal rights for participation in the elections and the fact that all the voters should have an equal number of votes, but the legally equal influence that these votes have on the election results. That's why there is a need for a fair development of the boundaries of the districts and how to make sure that the votes have an equal weight. And this shows the number of impact that the votes can have on the voting results. The fewer voters in the district, the higher level of impact that they may have on the election result. For example, in a single mandate district that has 1,000 voters, to select an absolute winner, it's enough to have 501 votes. While in a single mandate district with 5,000 voters, they need to get 25,000 plus one. The problem of the current code is that the stage of formation of the districts is outside of the election process, which makes it much more difficult for the candidates, the persons who want to implement their passive right, the process of appeals. The Code of Administrative Law of Ukraine identifies the range of subjects who have the right to apply to the court as primarily the participants of the election process. But at the stage of the formation of the districts, as now it is outside of the election process, the candidates do not yet have this right. They are not yet the subjects until the Territorial Commission registered them. And one person who is authorized to apply to the court is the voter. However, only if he or she can prove that the rights have been violated. As a result of the latest local elections, we could see the following situation, where the courts would dismiss the claims because the election rights had not been violated. And with this case law, clearly, we should have the only category of cases, the cases in terms of appealing the formation of the districts that cannot be even heard by the courts, which is inadmissible, of course. Another difficult issue I wanted to focus on is the low quality of the preparation of the commission members. In order to provide proper implementation of the election rights, this depends not only on the legal culture of the bearers, but of the persons who are authorized to organize the preparation of the elections. And the improper development of the commissions in terms of the professional level of its members is the result of some legal conflicts that require judicial reviews. In Western European election practice, we can see that a large number of election-related disputes can be avoided if proper conditions are established for the selection of commission members. In the current election code, there are no regulatory requirements in terms of professional competence of the members of the territorial or district election commissions. So there is a need to, in fact, impose these special requirements about the special profession. Article 34 of the election code only has one requirement for the secretaries, to be able to speak the national language. And the members of the election commission can be persons who are voters at the same time, and that's it. Now, when the members take the oath, they automatically become members of the commission. However, there are no requirements about the working experience or special training that they have undertaken. It is not in the law. However, a special knowledge of public law, administration, or special trainings whereby persons can receive their certificates, I believe that this should become a part of the guarantees for the proper ensuring of the voting rights of the citizens. Next, the need to formulate an issue about the deadline till which the results of the election should be established. We faced this problem at the latest election, the election in District 87, and while organizing the national election, the early election 2019, we had such a situation, District number 207. What happened there? Article 98 of the law of Ukraine on the election of members of parliament, and this is what in fact took place according to the law in those two districts, said that the election committee would establish the election results not later than 15 days after the voting on the basis of the voting protocols. But the law does not restrict the Territorial Commission as regards the time during which the election results should be established. It just says that the District Election Commission should establish the results after it takes all the protocols from all the precincts with the voting results. Incidentally, the same provision can be found in the election law today. But as the election system has been changed, perhaps we will avoid those complications. I don't know yet. So several times we had a situation when the deadline for making the decision about the election results is over 50 days after the voting. However, the courts have not yet heard the appeals about the results of the voting. And there are now different conflicts between the legal professionals as to the deadline. Some candidates who implement their passive electoral right find it beneficial so that the Central Election Commission, having all the protocols and within the deadline, official deadline, would announce the results of such elections, because this is the deadline, exhaustive deadline. While another candidate who believes that while establishing the results of the voting, the violation of the law took place, and one uses one's right for an appeal, one would not want for the Central Election Commission to establish the results. And whether we're talking about the inactivity of the Central Election Commission that would not establish the results within this substantive provision of the law. Now, if, however, it announces the results, it can open up the next stage, while 5 days after this decision, it has to make the results of the election formally public. And that means that the persons can be dismissed, and next the members of parliament can receive their formal certificate. The decision to register the member of parliament means that this person can take the oath of a member of parliament. In that situation, we see the law on members of parliament take effect. To do that, to, for example, early dismiss, let's say, the mandate of an MP because of the protocol of the election results. The law doesn't have that. That's why I believe that we should do it in a different way. If we have the protocol with election results, 5 days to appeal it, and 2 days for an administrative court to hear it, and 2 days for an appeal of that decision, then the CEC will in fact make it within the 15 days deadline, however, after the day when the protocol has been drawn to make a decision about the results.
I believe that election legislation related to this issue is to be changed to improve election procedures so that people could properly exercise their right to be elected. Dear colleagues, that's it on my part. Thank you very much for your attention. Ready to answer questions if there are any. Thank you for a very interesting presentation. Maybe we'll have Q&A at the end of this session, and then you'll have a chance to answer them. Marina Rusu, she's back with us. Sorry for technical issues. Let's continue with you. Good afternoon again. I said that elections in our country are conducted on the basis of direct suffrage right with secret vote casting. Election law covers the code that came into effect in 2007. We govern electoral rights not by patchy laws, but we are trying to collect all the norms and codify them in one act. At the same time, I would like to say that the electoral code in Moldova was reviewed in 2016 and 2017. And this revision was caused by the fact that we had lots of different amendments made, and we changed the election process per se, the appeal procedure, and that led to the fact that we had to review the entire code, the text of it. from what I understood from the reports of the previous speakers, there is an issue when election legislation is subject to change just before the elections, and that leads to the fact that the participants or the candidates don't have any opportunity to properly prepare for the respective changes and amendments made, and that complicates the exercise of their right, the right of the candidates and parties to fully exercise their rights. Along with that, getting back to the election disputes, I'd like to say that in Moldova, we see administrative disputes when it comes to any disputes that are caused by the elections. I take that similar in Ukraine, and the process of oversight as to the legality of the procedures in the course of the elections is comprised of four stages. The first, that's submitting appeals, and there we have the first level of control over the lawfulness of election. The complaint or grievance can be submitted by a physical person, an opponent that can appeal action in action or the ruling of the election commissions or bureau, as well as the actions of the opponents. Depending on the subject of the appeal, we can go to court directly without pre-trial dispute consideration, in particular in the instances when the complaint deals with the coverage of the election campaign. It is handled by the Coordination Council on TV and radio broadcasting primarily, but they can be submitted to the court as well. There is a conflict in our legislation that deals primarily with the fact that electoral disputes should be handled in the civil procedural proceedings under the administrative code, but the administrative code has some contradictions with the electoral code that leads to the conflict in law, and naturally it creates ambiguity for the parties with respect to the procedures as they are provided by law, and therefore they cannot choose the best effective conduct in this respect. We are ahead of elections, so on July 11 we are going to have elections, parliamentary elections in Moldova. Moldova is in the midst of the political crisis that is linked to the judicial crisis, executive power crisis, a legislative branch of power crisis. So given all that, any conflict in law can lead to large number of electoral disputes to be handled by courts. The next stage is consideration of complaints in courts. And, well, naturally, the appeal stage follows, if any. And you can also submit constitutional complaint. When it comes to the structure of administrative electoral disputes, so let me say that if it is presidential elections, then appealing the outcome of the elections is not provided by the electoral code. The outcome is confirmed by the decision of the Constitutional Court following the a provision of all data about the elections provided by the CC, and after the decision of the Constitutional Court about the results of the elections, post-election procedures of appeal are non-existent, which is an element of concern of the international observers that come to us to observe the elections, and the matter of concern for the lawyers and citizens of Moldova. The Constitutional Court decisions in Moldova are final from the moment they are delivered, and they are not subject to appeal. There is no procedure of appeal in them. And following constitutional decision about the outcome of elections, nobody can appeal the results of the elections. But as I said, we have an opportunity to submit complaint in the course of the election campaign, and until the voting results are confirmed and made public. When it comes to local elections, the results there can be appealed. We have compliance with international standards here. A few words about the complaints that deal with the election campaign funding. If it is parliamentary or presidential elections, then in Moldova we have case law when national courts excluded one party as the running party at the elections based on the results of funding. To be more exact, it was complaint that was submitted with respect to the funding of this party. The decision of the court was based on the fact that the source of funding for the election campaign of one of the parties were not transparent. The CC did not receive sufficient grounds to verify sources of funding, or rather their compliance with law and requirements. And the decision also stated as the ground of substantiation that the political party of the claimant spent 5 million lei of undeclared assets to buy 11 vehicles. Given the fact that in Moldova we have an issue when the voters are actually delivered to the polling stations, and at the recent elections we had around 300 complaints submitted, were mainly dealing with the fact that voters were transported to the polling stations to vote. And a lot of these complaints were confirmed. The voters indeed were transported to polling stations, and it was proved by evidence. At the same time, this decision was appealed by the claimant, by the political party and its leader. They went to the European Court of Human Rights, and the European Court in its decision stated that the Republic of Moldova violated the rights of a political party and its 11 candidates that were running on party lists at these elections. The ground of the violation was mentioned as the national court's decisions excluded this party due to ambiguity of finding, and it was arbitrary conclusion made by the court since the court didn't have relevant facts to prove that. European Court also said that the guarantees against arbitrary decision were not provided. I'm sorry, unstable internet connection. I missed some part of it. So this satisfaction was awarded. I'm sorry, I lost the sound. We do have a technical issue with the speaker. Could we restore the internet connection? Well, we are trying, but I'm not sure that it will be fast to fix it. Let's wait for a minute. If we are not able to restore the connection, then we'll move on. Unfortunately, it will take longer. I would suggest moving on. Thank you. Apologies for this technical issue with Ms. Russo. Let's move on, and I'm happy to give the floor to the judge of the Supreme Court in the Administrative and Cassation Court, Doctor of Law Olena Houbska. She's going to talk about the role of the CC in determining the results of local elections. Thank you. Marina is back. Okay. Marina, over to you. Apologies for technical issues. I guess that's internet connection. Let me just cover one interesting dispute that was really high-profile dispute, and it led to mass protests in our country, the most large-scale protests in our country. That's the electoral dispute that is linked to revoking the elections, local elections in the capital by the court. It was the decision that was based on the fact that there were violations of the day of silence. That's the day where you cannot campaign. However, there was a live broadcast in Facebook then. Additionally, the court also stated that there were more than 250,000 visualizations linked to the video material. So the court decision points out that both candidates that were running violated this regulation. The results were revoked, and the candidate who got the largest number of votes didn't receive the mandate. The decision was appealed, but it was upheld by the Court of Appeal. After that, the candidate went to the European Court of Human Rights, and as a result of the negotiations with the European Court of Human Rights, in this case, Republic of Moldova was provided an opportunity to substantiate violations under Article 10 that was part of this decision. That's a violation of the freedom of speech. Unfortunately, Marina has really serious technical internet issues, and reconnecting will take more time. I would suggest moving on. Olena, apologies for interrupting. Now we are carefully listening to your presentation. Well, that's internet and we don't have control over that. I'm going to talk about the role of the CSC in determining the results of local elections. And from Moldovan experience, let's move over to Ukrainian experience. Elections, that's the form of direct power of people that is provided for by the Constitution. We all know that in Ukraine we have different types of elections. That's presidential elections, the parliamentary elections, and local elections. Talking about local elections, and we had recently local elections in our country under Article 202 of the Electoral Code of Ukraine. The system of election commissions are the Central Election Commission, that's the highest level commission. For other election commissions, Territorial Commission, and the District Commission. The powers of the commissions, including the CSC, are provided by the effective legislation, including the Electoral Code of Ukraine and the law of Ukraine on the CSC. However, let me just state here that following the recent local elections, we realized that there is a diverse case law, since electoral legislation is so imperfect that the same provision is interpreted differently by different courts. And here, let me point out to the following. The provision was interpreted differently, and that was namely the right of the CSC to determine the results of local elections. That was interpreted differently. If the CSC has this right, and in some instances it does as by law, then there is an interesting question here. So what are the functions of the CSC then? Whether that's the functions of the CSC or that's the functions of the Territorial Election Commission that CSC performs. And there is a third question here. What would be the jurisdiction for this type of electoral disputes? Since academia, judges have really diverse opinions, let me cover two positions that are opposing and different.
According to the first position, if we analyze Article 18 and 18 of the law of Ukraine on the Central Election Commission, as well as articles of the Election Code of Ukraine, one can conclude that the Election Code of Ukraine gives the CEC the competence to establish the election results only during the elections of the President and of the members of Parliament of Ukraine. At the same time, when the local election takes place, establishing the results of the local election, only the Territorial Election Commission can do that. Now, talking about that line, that position, in that case, one could say that the CEC takes over the authority of the Territorial Election Commission. It uses its competences, its mandate, and in fact, it replaces the TEC. Besides, if we look at Article 1 of the law of Ukraine on the Central Election Commission, it says that during the local election, the Central Election Commission shall carry out the functions of control, methodological competences, and consultation services. And then one can come to the conclusion that in that case, the CEC carries out the supervisory function. And there is even such a mandatory condition as improper implementation of one's competences by the Territorial Election Commission. Yes, this position is substantiated, it can exist. However, let's look at it from another angle. The law of Ukraine on the Central Election Commission really suggests a number of cases when the CEC can establish the results of elections. It says really that it should be during the presidential and parliamentary election. At the same time, if we analyze Articles 17 and 21 of the law of the Central Election Commission, there we see that the CEC can carry out the functions not only on the basis of the election code, the law on the Central Election Commission, but according to other laws as well. If we analyze Article 33 of the election code, we would see that the competences of the Central Election Commission are established by the Constitution of Ukraine as well as other laws. Article 205 of the Election Code of Ukraine says that in case of where the Territorial Election Commission does not comply with the code requirements, the Central Election Commission can establish the results of such a local election. Therefore, according to Article 1 of the law on the Central Election Commission, the CEC carries out the supervisory function and consultative function. But what is it, supervisory function or control function, as the law says? And the question here is because there is no definition of the control function in the law, and it can be interpreted quite different ways. For example, Mr. Kluchkovsky, present here today at this conference, believes that the system of administration, administrative bodies, has two functions. The first one is the administrative function, and the second is the controlling function. So the administrative function is the organization, preparation of the election, while the controlling function is ensuring that law and order is complied with during the election campaign, protection of the voters' rights if they are violated. And this function gives the Election Commission the authority to hear election-related disputes. The question is, what are those controlling competences? The attempt to decide it has been made in many judgments. For example, in the decision of the Administrative Court of 2021, it said that the issue of controlling authority covers the decisions made by the Central Election Commission as regards the commissions of a lower level. And this kind of control targets the activities or inactivity of the subordinated bodies. In other words, it's the decision on whether the activities or inactivity of the territorial election commissions or any other election commission of a lower level were correct. Therefore, one could agree with the other legal position, suggesting that establishing of the local election results by the CEC cannot be regarded as performance of control function, because its purpose is not to check the correct actions of the TEC, while the CEC makes its decisions independently. In other words, it performs its own functions that are established in by the current legislation. And as there are two positions, the question is of the jurisdiction of those cases. Because based on which position should prevail, it would be the jurisdiction of the Supreme Court on the one hand, or the Administrative Court of Appeal on the other hand. So, if we analyze Articles 22, 273 of the Code of Administrative Justice in Ukraine, we would see that the jurisdiction of the Supreme Court as the first instance court includes cases about appealing activities or inactivity of the Central Election Commission in terms of establishing results of the elections, while all the other decisions about activities or inactivities shall be appealed with the Administrative Court of Appeal in the appeal district, including the city of Kiev. In that case, if we stick with the position that the Central Election Commission, as it establishes election results according to Article 205 of the Election Code of Ukraine, will take over the competences of a TEC and functions as if replacing it and committing actions in lieu of the TEC, and as a matter of fact, it performs the function of control. In that case, such cases will be in the jurisdiction of the Sixth Court of Appeal as the first instance court. If, however, we believe that the other position prevails, where the Central Election Commission performs its own powers rather than controlling powers, then the jurisdiction of the first instance court would go to the Supreme Court. Therefore, analyzing those legal positions allows us to conclude that we have a different interpretation of the same legal provisions, as a result of which the election code provisions would have to be further studied and improved in order to avoid certain collisions and conflicts and amending them. That's the end of my presentation. Thank you very much. If there are any questions, I would be happy to answer. Thank you very much, Ms. Hupska. Thank you very much for this very interesting presentation. I'm sure there will be questions to you at the end of the session. I would like to continue our work and to give the floor to head of the 8th Court of Appeal, Doctor of Law, Oleg Zavarucha, who will give us a presentation about the establishing the results of the interim elections. Thank you. Good afternoon, dear members, dear participants. First of all, I want to thank the organizers of this international conference for the invitation to participate. And my presentation I wanted my presentation to comply with the general subject of this conference and would be related to practical application of the election law. Namely, it will deal with some very recent court judgments. Let me start by saying that the disputes on the relations related to the election law are a special category of cases, and although we do not get them regularly and only during the election process, the administrative courts are very sensitive toward this category of cases. It's probably not accidental that the courts at the time when they hear election cases work under special rules, and that means round the clock, working on weekends, and this regime lasts until the end of the election campaign. There are several reasons for it. The first one is the fact that this category of cases is within the urgent category of cases where a quick response of the courts is required. Second is protection of one of the fundamental political rights, the right to elect and to be elected. That's an important guarantee for direct participation of a person in the public governance and management. And third, effective protection of the rights, freedoms, and interests of a person in the area of public relations is the objective of administrative justice. The election processes of this year and last year that have been mentioned many times by the previous speakers were quite complicated as regards the work of the 8th Court of Appeal, Administrative Court, in view of the number of lawsuits and as well as the high-profile cases. As a result, the court, during those two election campaigns, considered an unprecedented number of election-related cases. While hearing them and while deciding upon every case, the courts should provide proper legitimacy, proper application of the law and protection of the legal rights of the people at every stage of the election process. But of course, it is the establishment of the election results, which is the final and most important stage. In view of its role in the court, in the case law, the largest number of cases related to the election process takes place at that stage. According to Part 3 of Article 77 of the Constitution of Ukraine on the election procedures of the parliamentary elections established by the law, the Constitution of Ukraine also says that it's only the laws that establish the procedures for organization of the elections and referenda. The Convention on Human Rights and Freedoms says that the high parties commit to have free elections by secret ballot in a situation that would ensure free choice of the people as they elect the legislative body. At the same time, as practice has shown, legislative gaps as relates the regulation of the interim elections of the MPs have caused a number of court cases during the interim election of the 28th of March 2021. Let me give you some interesting, from the point of view of the application of law, cases from the practice of the 8th Court of Appeal. With a resolution of the Central Election Commission, an interim election was announced in the single mandate district number 87, and according to point 2 of item 42, the legal regulation of that election was to be made on the basis of the law of Ukraine on the parliamentary election. Following the resolution of the CEC, a district election commission was set up, and on the 28th of March, the interim election took place. The district election commission, as a result of looking at the documents from the precinct election commissions, made several resolutions suggesting that the voting results were invalid. All of it was related to the unlawful, the way the District Election Commission thought, inclusion of the persons into the lists who were unable to move on their own. Part 1 of Article 92 of the election lists the exclusive number of conditions under which a territorial commission can decide that the elections are invalid, as a result of which one cannot for sure establish the results. And one of such conditions is the voting of the persons who were included to the voter list without any grounds in the amount that exceeds 5% of all the voters who have received the ballots. Part 16 of Article 94 of the law on elections suggests that the District Election Commission can decide that the voting at a certain district was invalid only when it recalculates the number of votes at a certain precinct and finds the circumstances that are listed in Article 92, Part 1 of the law. Appealing the resolutions of the District Election Commission were motivated by the fact that during the recalculation of the votes, facts were established where ballots would be given out to the persons whose number exceeded the 5% of the overall number of the voters who had received the ballots. To establish the number of facts of the violation of votes, the District Election Commission based itself on the overall number of the persons who were unable to move on their own, who were registered at those disputed precincts and included into an additional voter list regardless of whether they had received the ballots. The court, in those decisions, to which I would refer at the end of my presentation, did not agree with such an interpretation made by the District Election Commission of Article 92 of the law, because the construct of the legal provision, which is the basis for invalidating voting, suggests that people should not only be put without any grounds on the voter list, but that these people should vote in a number that exceeds 5% of those people who have received the ballots. In all the cases that the court dealt with, the court did not see any confirmation of the fact that all those persons participated in the election, namely that they had received the ballots, and therefore it meant that they dismissed revoked the decisions, the disputed decisions. Yet another situation was the incorrect inclusion into the voter lists of the persons who had not submitted their announcements, their statements suggesting that they were sick, which would be confirmed by the medical institutions. Article 86 of the law suggests that a person who has been put on the voter list at a precinct, but because of one's age or disability or health condition cannot move by himself or herself, the TEC would allow one to vote at one's home. To organize such voting for the people who cannot move by themselves, the TEC on the very last day before the voting day at its meeting would produce an extract from the voter list according to a separate special form, which would include in two categories without the decision of the commission: the voters who are permanently unable to move by themselves, and there is a special marking for such persons in the voter list. And the other possibility is the voters who are unable to move by themselves on a temporary basis. And this should be confirmed with a medical certificate. According to provisions of parts 5, 6, and 8 of Article 86 of the law, the voters who temporarily cannot move by themselves can submit their own application written by themselves with a request to make sure that they can vote at home or at one's residence. This application, together with a medical certificate about one's health conditions, should be submitted within a certain period of time to the District Election Commission. An application of the voter suggesting that one should vote at home should be registered by the Commission. The analysis of those provisions has allowed the court to conclude that the information of the voters who are permanently unable to move by themselves and who, within a certain period of time in writing, did not inform the commission that they wanted to vote at home, should be part of the voter lists, and they should be put on an extract to those special voter lists, and the ballot should be given to them. Therefore, the court decided that the position of the TEC that these persons should also provide their applications, and medical certificates is not based on the law. To conclude, let me say that the disputes about establishing election results are really some of the most complicated ones in the work of the courts, as we understand that the role of every judgment, of every decision for the final election results, the judges take a very balanced approach to such cases. Besides, public control and public oversight over the election results and the media component, they create additional pressure upon the judiciary while making their decisions. For this reason, good quality legal regulation and compliance with the law by all the participants of the election process is extremely important as guarantees of the fact that the election rights would be effectively implemented, and if need be, they would be properly protected by administrative courts. Thank you very much. If there are any questions, I would be happy to answer.
Thank you for your very interesting presentation, and thank you for reflecting in your presentation recent decisions and developments. Thank you. Dear colleagues, dear participants, let me thank the presenters for their presentations. While very interesting presentations, let's move over to the discussions and QA. There were questions to Mr. Broker. The first one was the following. Miroslava Bilak is asking, Mr. Broker, how do you use the principles of the electoral law, especially non-explicit ones, when handling electoral disputes?
So,
how do you use the principles of electoral law, especially indirect ones or non-explicit ones, by the administrative courts when handling electoral disputes?
yeah. So first of all, it's a matter of the constitutional court, not of the administrative courts, as I mentioned. And there are 5 principles of voting which are written in the Constitution in Article 38, similar as in 71 Ukraine, and there is only one that is unwritten, and the unwritten one is the public nature of the election. It's known as the Publicity Principle, as an unwritten principle of the right to vote. This means that all the key steps in the election, the nomination process, the voting procedure, except the marking of the ballot paper itself, of course, and the establishment of the election result must be carried out in the public eye. And because of this long time we are dealing with such cases, with such electoral cases, it became more and more sufficiently in each case to form them out over the years. It's now about 70 years of jurisdiction in these cases, and so they are much clearer now as they are only written in the Constitution. And so that's what you are dealing with, forming it for individual cases and making it easier for you, but also for the administration to keep the election process in touch with these principles.
Дякую вам за відповідь. І ще
Thank you for your answer. There is another question to you.
Чи є порушенням принципу таємності, коли виборець
Would it be a violation of a principle secrecy if the voter himself discloses how he or she voted? For instance, he shows the ballot to the other person.
Yeah, that's a very good question, because it fits to what we just said about the public nature of the election. But this, what you mentioned, concerns the principle of secret vote. So you have to mark the ballot paper in the booth itself. But outside the polling station, not only the booth, you can tell everybody for which party or candidate you voted. That's clear in a democracy. But nobody can force you to do so, and that's very important. But which is strictly forbidden is to show the marked ballot paper or even take a photo of it and post it. And the reason is obvious. In a similar case, the German Federal Constitutional Court ruled last year that even a member of parliament is not allowed to take a photo of its voting when there is an election in the parliament, the election of the Chancellor in the parliament. the member of parliament is not allowed to take a photo of his voting and show it, because otherwise he might be forced to do so in the future. Such things are more like a Soviet system than democracy.
Thank you. And there is another question to you, Mr. Broker. What do you believe? Is it a violation of the principle where nobody can be a judge in the case when the parliament makes the decision as to the results of the elections? So the parliament determines the lawfulness of the parliamentary elections.
Yeah, that's also a very good question, and it's a very special German system of the control of the elections, that the parliament is in charge in this process. Of course, there is some kind of controlling yourself, but you have to see the parliament is no judge. And it has a very long tradition in Germany, this system, since 1919, and it's to strengthen the parliament. The decision of the parliament is only the first step of the special complaints procedure. It would be a great problem if there is no judge in the back after this first step. But the decision of parliament, of course, is no judicial control, and therefore the decision of parliament is fully controlled by the Constitutional Court in the second step. And what's also very important, it's no political decision of the parliament. Well, of course, they are politicians, so they keep this in mind, but they have to come to their decision in accordance to the law. It's no political decision. But let me say it once again, most important is the fact that in the second step of this system, the Constitutional Court controls what Parliament said. They control the decision of the Parliament in these cases. Okay.
Thank you very much indeed for your answers. Thank you. Appreciate it, Mr. Broker. And there is another question to Hinteras. The following question to you. Political advertising provides for dissemination of the information with the aim to influence the motivation of the voters. How do you identify the purpose if the person advertising is against the alleged motivations?
Please repeat. I will switch on English because I don't understand correct way.
Political advertising provides for dissemination of the information with the purpose to influence the motives of the voters. How the court can establish this purpose if the subject that is disseminating this information is contradicting the alleged claims? So we are talking about the hidden advertising here.
Yeah, we had a few cases. We had a few cases in this matter, and in general, I can answer on this question in this way. Every situation is geared in very special circumstances, and we are in general, we are the court, the instance which revise the decisions of election commission. And first step is when the election commission define and find the all circumstances how to define this situation in concrete case. And after that, of course, we use all international and our national, in general, constitutional principles to define the special circumstances in the case which is heard in our court. We don't have common answer. I don't have common answer in general law in all situations. It is very special circumstances in concrete case, and we are responsible for judicial review of this situation and share the opinion between our judges to discuss in this matter and make decision.
Дуже дякую, пане Гінтерс, за надану відповідь.
Thank you for your answer.
In our law, as you understand, because it is not possible to define the concrete situation, define some common rules on this, because we use all instruments in our law, principles which comes from constitution and common principles in law.
Дякуємо, пане Гінтерс, за
Thank you, Gintaras, for your exhaustive answer to this question. Let me thank all presenters again. We exceeded the time for this session, so let's conclude. Session 2 will be moderated by Olena Hubska, the judge of the Supreme Court, Doctor of Law. Since we exceeded the time, let's take a 10-minute break and we'll continue then. Thank you to all of you.